Okay, so let's get into the questions. I'm really happy to announce that we had over 150 people here today on Facebook Live and on Zoom for this class here today. I think it's because it's a really good topic that a lot of people have questions about and that they are dealing with, and that's causing them to feel burned out as a board member. And so really happy to see such a great participation here today. Let's get into our questions. It looks like we have quite a few questions, about 14 or 15 as of right now. Okay, so our first question here today is from a board member. This was resubmitted from a First Fridays call due to a connectivity issue. So we weren't able to answer this one on our First Friday in March. So we're going to push it to today. We are a planned community, and our CC&Rs say we can charge a late fee of up to 25% of the monthly assessment, which is $40. So it would be a $10 late fee is going to be 25% of our assessment. However, our management company charges significantly increasing. They're charging processing costs to the owners for every month they're delinquent. First month and second month, they're escalating at $20. Third month, it's going to be up to $70. Fourth month, it's going to be up to $140, and then $180 to send to an attorney, fee to send the file to the attorney. Is this allowed? This processing fee was never authorized by the board and was not in the management contract, other than saying processing fees may be charged. Okay, so we're starting to see a lot of this occurring now, mainly because a lot of management companies in Arizona are being bought out by large national management companies, and they're coming in, and they do have some new charges that they are implementing for homeowners. So first things first, I think you need to talk with your attorney. Make sure that your attorney is not in any way having a special relationship with the management company and that they are your attorney only. And our firm is one of those attorneys that we only work with the associations. We don't have any special relationships with the management companies. We don't represent any management companies. We represent associations. You can always count on us to give you advice that is going to be in your best interests. Okay. So first things first, we got to be careful because state law, if you're a planned community, already outlines, how much you can charge. So you can either charge $15 or 10% of the assessment rate. So if, you are charging a $10 late fee, that is consistent still with what the planned communities Act says. Now, there's these other costs, which are like processing costs. I'm not really sure I understand, maybe like late fee or like fees to move the file to the attorney, or maybe I'm not sure what the processing would be. Maybe they're sending the invoice to the owners each month. I'm not sure. We're going to have to look at whether or not their management company is authorized under the contract to do that. Just the ability to say that, hey, we can charge processing fees, I'm not sure that's going to be enough for them to be, incurring these large expenses on the owners. And the owners might start pushing back on it and say, yeah, I'm not paying that. So this is a serious issue. We need to look at the management company. We need to open the dialogue with the management company. You need to get your independent attorney for the association involved to help you navigate this process. Okay, next question is for a board member. I have a homeowner submitting to install a separate structure for a home office and guest quarters, so kind of like a guest house. How does the ADU law impact existing CC&R's specific size requirement of the structures? So there is a law that went into effect recently on ADUs, which I think is alternative dwelling units, is how you say it. And basically, the state of Arizona passed a law that legislators passed a law and the governor signed it, promoting the ability to have ADUs and telling cities that, hey, this is something that, we're promoting. Even though there's that law out there and that cities may be more restricted in denying applications for ADUs, it does not mean that the association can't still enforce any restrictions that they have in their documents regarding, accessory dwelling units, regarding guest houses. We still can go through our normal review process, and, we're going to have a pretty good reason why we're denying it. So maybe the documents, the CC&R specifically say no accessory dwelling units. Maybe It talks about maximum square footage. I mean, there's going to be different ways to analyze it. If the board is going to deny the right to have an accessory dwelling unit, you definitely want to dial in your attorney and talk it through and make sure that the denial letter is going to be something that is going to withstand any court challenge that the owner may make on it. But yes, you still have the right to have your architectural committee or your board review that application. And if you have a valid legal reason to deny it, then you certainly have the right to do that. And that state law, it's not going to impact that in any way. Okay, the next question is from a board member. Our board needs to revise some policies. What is the best way to define revisions outside of the limited time in monthly board meetings? Less than a quorum at a meeting to discuss these policies? Email suggestions back and forth? Do we need to vote in an open session to form a temporary committee to work on it with or without non-board homeowners? Our property manager says we cannot decide how to proceed unless the topic was included on the current agenda. Is that correct? Well, best practices would be, have an agenda for each of your open board meetings and your executive session meetings, and try to state with particularity what you're going to be discussing and voting on. So best practices would be put that on the agenda. That, hey, we want to revise some policies. I would recommend that you have less than a quorum of the board discuss this, outside of a board meeting so that you're not violating the open meeting law. You could certainly appoint a committee. Just make sure that there is less than a quorum of the board on the committee, so you're not violating the open meeting law. Run those policies that you're planning by your attorney to make sure that they give legal approval for them, and discuss and vote on them as a board in an open board meeting. Okay, next question, number 4. This question says, why are there multiple HOA governing documents that are redundant and contradictory and were established by a long gone and irrelevant builder developer? Shouldn't we be allowed to revise, simplify, and clarify them into rights and responsibilities that are more appropriate for our community and are current with the times? Okay, so great question. So the documents that are typical for an association are the plat map, the CC&Rs or the declaration, the bylaws, the articles of incorporation, and then the rules and regulations of the association. You really do need to have those 5 different categories of documents, and you can't just, put them all together in one. So each one has a separate purpose, and the documents can't contradict each other because there's also a statute that says that the hierarchy of the documents is plat, CC&Rs, articles, bylaws, rules. Anytime there's a conflict between any of those documents, like maybe one document says one thing and another document says another thing, whoever's higher in that hierarchy is going to control. And so, yes, we do suggest amending CC&Rs, especially if, they're really outdated or there's been changes in the law or the developer's long gone. We have a great cheat sheet on this called How to Amend Your Association's Documents, a 5-step plan that's a really effective tool to help your association through that process. You can find that on our website at mulcahylawfirm.com. So I would be opposed to a formalized recorded rights and responsibilities. I think the Maricopa County Recorder or any other county recorder would even know what to do with a document like that. If you want to do an informal summary sheet of the documents and call it that, you certainly can do that, but you still need to keep those 5 formal documents. Okay, question number 5. What are the red flags of a dysfunctional HOA and board? Okay, this is a really good question. I'm so glad this person asked this. So typical red flag is going to be you've got board member burnout. The board isn't accomplishing anything. All they do is go to board meetings and fight or just deadlock on votes. Everything is 2-2 or, whatever, 3-3. Hopefully you have an odd number of directors so that you don't get into that situation. And just in general, there's an overall dissatisfaction by your owners that like, hey, nothing's happening here. Like we are not accomplishing anything as a board. So those are probably the biggest red flags that I would see. Question 6, can a violation fee be imposed if a violation has not been denied or the homeowner has a chance to be heard? So in order for a fine to be levied against an owner, we have to give the owner notice of the violation. It has to be a violation in your documents. So it's got to be in the CC&Rs, bylaws, or rules. And we have to give the owner an opportunity to be heard before we levy a reasonable fine. And so you really have to set this up as a process. You got to give notice of the violation, right? Make sure that violation actually is a violation of something in your documents. We've got to give them an opportunity to be heard, which could be the right to send an email back with their position or the right to come to a board meeting. The board chooses what the opportunity to be heard is, okay, and give them a reasonable time to do that. And then after the time period for the opportunity to be heard is expired, we look at what they wrote us or if they didn't respond, and then we'll make a decision. We're going to levy a fine. It has to be reasonable, and then we're going to have to notify the owner of the fine. So that's the process that you make. So, if they haven't been given a chance to be heard, then obviously you're not following what the fine laws are in Arizona. If a violation has not been denied, I'm actually not sure what that means. Maybe it means that somebody built something and they didn't get approval. It hasn't been approved or denied. In that case, you still can fine because they violated the documents for not submitting an application, right, to get something approved, and what they built would never have been approved. Okay, question number 7. Can an HOA host or sponsor a movie night at the community pool? What should be considered liability-wise? Oh, this is a good question. Lots of information out there on movie nights and some of the laws that you have to comply with to deal with movie nights. So first, you're going to need to hire a company to, break the movie in and to use the big screens so that you can have the event. You do not want to just buy a screen and then just stream a movie from your phone, because that's going to potentially violate copyright laws and you could be sued. And we have seen that happen to a couple of associations having movie night in the park or whatever. So just recognize that you need to be professional in how you do this. This is a community event. You've got to hire the company to bring in the screen, or if you have a screen, you got to hire the company to show the movie, and you got to pay the fee to use the movie. If you're having it at the pool, I always worry about safety and drowning. So you're going to need to consider how you're going to manage that. Maybe you hire lifeguards to supervise, to make sure that everybody's safe that evening. Those are just some initial suggestions I have on something like that. Probably a lot safer just to have it at a park where you're not involving water. But those are some suggestions for you. Okay, question number 8 from a board. Can you explain the process for an HOA setting up a capital improvement project and its limitations? So really what I would do is, if your association is considering a large capital improvement project, you need to do a lot of planning. Okay, so number 1, you got to come up with, what exactly do we want to do? And sometimes you bring in a company from the outside who helps you plan the capital improvement project. Now, it just depends how large your association is. That's probably going to be for larger associations with a lot of amenities and a lot of lot owners. Sometimes the board is that entity, and you're just planning, to redo the pools, and maybe you're consulting with your management company and your attorney. You got to define, how large is this project? If it's the scope of this project is really quite large and it's going to be like a master plan renovation, you may want to bring in a company. And these companies, I have the names of several that are outstanding. Basically, what they do is they will do a survey of your members to find out what amenities they think need to be improved, what amenities they would like to see. Just get feedback so that we know how the homeowners are feeling about the amenities in your association. And then we plan from there. If it's the board just doing this part of the planning because you're a small association, don't have the money to bring in a company like that, I would also recommend doing a survey using SurveyMonkey, maybe have a town hall and have people contribute how they feel about things that way. And then we need to kind of start planning and pivot, right? You got to come up with, what is the scope of the project that we're going to do? We're going to have to get bids. Are we going to have a general contractor? These are all different things that you need to consider. We have a great cheat sheet called Bidding and Contracting that I would recommend that you look at on our website at mulcahylawfirm.com. you're going to have to think about funding. Are we going to have to take out a loan? Are we going to do a special assessment? Do we have the money in our reserves to pay for this? Will this deplete our entire reserves? How are we going to put the money, back into, make our reserves sufficient, for future things that may come up? Lots of different things to think about with capital improvement projects. So reach out to your trusted advisors, your management company, and your attorney. That should be your first stop to talk about where we are now and where we want to go and what our plan should be to get there. Okay. Question number 9. What is the legal standard for bylaws and rules that were in the past recorded, but current ones are not recorded? Do we need to record new changes or not? So bylaws and rules are never recorded. The recorder's office may allow you to do it, but it's not proper to do it. So just make sure that the set of bylaws and rules that you have that are current are dated, and that you're providing those to buyers. If they're, a disclosure statement is requested and we're giving buyers the documents of the association, make sure we're giving them the current ones. Also, if an owner asks for a copy of the bylaws or the rules, make sure you're giving them the current ones, which are going to be the ones that are in the association's possession and dated later than the ones that are recorded. Okay, next question, number 10 from a board. How would you deal with an HOA president not providing executive board packet until just before the meeting? How could a director force the president to give the directors time to review? I'm kind of laughing at this because my association does this exact same thing. So it's kind of a balancing act. Okay, so I do have sympathy for the president because executive session topics are always, most likely, like 75 to 80% of the time, they're going to be last minute. Like, hey, we just got a letter from this attorney who's saying he's going to sue the association. And so oftentimes things come up last minute, and we're going to try to push it in to talk about it at this meeting because we can't wait another 30 days because this is hot and this is a deadline. So I sympathize with the president trying to get the packet out early, because sometimes things come up at the last minute. Now, if I don't understand what the president's position is on this, so here's what I would do if I were in your situation. I would ask, if there's any way that we can get this information earlier and see what the president says. If they, maybe you're self-managed and maybe, it's tough when you're self-managed. You're trying to put all this stuff together, at the last minute. Maybe you can offer to help in some way. Maybe as a group, you come up with protocols as to, hey, we're going to try to get this information, out 2 days before. But just so this is a very common issue because last minute problems come up all the time. Okay, next question. Let's see. Senate Bill 1246. Where is it at, and do you feel it is negative for condominiums? Okay, Senate Bill 1246 is the proposed law in the Arizona legislature this year. It applies only to condominiums. It has passed in the Senate and is now in the House. It basically adopts the same threshold requirements before an association can foreclose that were adopted by the legislature last year for planned communities. So it says that we can't foreclose unless an owner owes 18 months of assessments or $10,000 in assessments only. It used to be 12 months and, you have to be 12 months delinquent and, I think it was $1,200 previously. So it makes it harder to foreclose. Is it really impacting our foreclosures for planned communities? Not really. Truthfully, it's not really. So, do I want this? No, because I think it's more impactful to condominiums because condominiums typically have, a higher assessment rate, and the ability to foreclose sooner is beneficial because we're counting on that money. Got a bunch of owners that aren't paying. We really need to take legal action, get them to pay. So is it the end of the world if this passes? No, we will adjust, but I would prefer if it didn't pass this year. Okay, next question, number 12. Looks like we're up to 20 questions from a board. For the homeowner forum portion of an HOA meeting, can you please outline how brief or descriptive the meeting minutes should be related to homeowner forum comments? All I would say is there was a homeowner forum from 9 a.m. to 9:13 a.m. That's all you have to say. Remember, meeting minutes are what was decided at the meeting, not what was discussed. Question number 13. Our board seems to feel that if it's called an executive meeting, the homeowners are not even informed. They appointed a new chair, which was also the new homeowner, in an executive meeting. What should a board of a small HOA be allowed to meet regarding without notifying the owners? Okay, so you need to take a look at our cheat sheet on open meetings because we talk specifically about executive sessions and what topics can be discussed in executive sessions. So the typical topics that are talked about in executive session are going to be advice from your attorney. If we're involved in any pending litigation, if there's active litigation right now, or if we're thinking about suing someone or somebody's threatened to sue us, we can talk about that in executive session. Personal health or financial information about an owner or independent contractor, an employee of the association, and job performance of the association. Those are our most common executive session topics. Appointing a new chair of your board, that's not an executive session topic, and they shouldn't be doing that in executive session. That should have been done in the open session. Okay, next question, number 14. If a homeowner doesn't like the board's answer and goes to individual board members to get the answer they want and keep questioning, when does it become harassment? Okay, so right there, problem, right? The homeowner should only be able to talk to the board in the board meeting setting. So if the boards are opening the floodgates and allowing individual member to talk to individual board member outside of the meeting, I think that's a problem. You should not be allowing that. Remember what I said earlier today? If a homeowner comes up and wants to talk to you about something and you are a board member, you need to get out of there as fast as you can. Be nice, be polite, but move out of there quickly. I appreciate you, trying to reach out to me. The appropriate place to discuss this is a board meeting. I'm sorry, I can't talk about this with you. I need to move along. That way you never even get into the problem about polling individual board members to try to wear them down to get what you want as a homeowner. That's never going to happen. The only time you're going to be talking about things is with the full board. Okay, question number 15. When a CC&R statute or architectural guideline is being violated by a community member, what types of criteria or reasons or questions does the board ask themselves or discuss when a motion or variance is made and seconded? So when you have a violation that's presented to the board, hopefully your manager can give you a verbal description, or a board member, if you don't have a management company, pictures. You just have to look at each situation on a case-by-case basis, right? And if it's questionable and you're not sure how to proceed, talk to your attorney and get their advice or opinion on it. So, is it a violation of the CC&Rs or the rules? If it is, you probably need to act on it. If it's a violation and it's existed for more than 3 years, you got to talk to your attorney like, hey, can we still enforce this? These are the type of questions, that you should be asking. Question number 16. Our property manager does not walk the property and relies on the board to provide information on violations. However, the management company and the board president decide to enforce the rules for only some of the owners. Additionally, the board president communicates with homeowners directly by text. Is this a problem for the association? So lots of problems on this question. Okay, first of all, if you have a property management company, they should be doing weekly inspections or bi-weekly inspections, twice a month or every week as part of your management contract. That should be something that they're doing. A lot of violations are brought to the attention of the manager from the board. I serve on my board. I can tell you I see things that our manager doesn't always see because I see it when the manager's not in her office, right? And she's not walking around the property the same way I would be when I'm walking our dog. And so that's something I'm not as concerned about, but it shouldn't be the only way for violations to be addressed. You can't do selective enforcement as a board. So you're indicating that maybe that they're enforcing it on some people, but not others. That's a big no-no. You have to treat everybody the same. Now, there are situations where you may not be able to enforce something against an owner. If the violations existed for a long time, we may have waived our right to enforce it. So we might have to treat somebody differently because of that legal principle. But for the most part, you should be looking at everybody's lot. If they have a violation, everybody gets the violation. Board president communicating by text with owners, big no. Don't do that. You should be having owners only come to the meeting to talk about issues. Okay, next question, number 17. The plat is the top document. Are those required to be filed everywhere? So the plat is actually the first thing that's recorded for your association, and the first thing actually that's introduced to the city or town that you live in when a developer wants to build an association. So it's kind of like the first document. It outlines how the community is going to look, where the lots are going to be, where's it's usually a couple pages, and it has the name of the association at the top, and it says, here's where the common areas are going to be, and here's where the lots are going, here's what it's going to look like in the community. And they take that to the city, town, and municipality, and they approve it. And then, they move forward with creating documents for the association. So are those required to be filed? So yes, the plat is always recorded with the county recorder's office. Next question, number 18. What are the rules around towing vehicles? Do homeowners need a notification first like they would for a fine? So I'm always cautious on towing. Towing, to me, usually equals a lawsuit. So people get really upset when their car's towed. So a few thoughts on towing. It has to be in the CC&Rs. The right to tow has to be in the CC&Rs for the board to enforce it. It can't just be some rule that you've created. It has to be in the CC&Rs. If you're going to tow, make sure that you are following Arizona law on towing. You have to have certain signage. You should be using a professional, licensed, and bonded towing company. And just recognize that if you just, tow somebody and they've had no advance warning, they're going to be really upset. So I would start with a sticker process where the towing company comes through, puts a really sticky sticker on the driver's side door, on the window, indicating, hey, you're in violation. Here are the consequences if you continue to do this. Make sure that wherever they're parking, that it's in the CC&Rs, that they can't park there. Or maybe it's, a red zone, where the curb is a red curb and they can't park there for emergency purposes. But you want to have the justification to tow in the CC&Rs, and then you want to be on solid ground that they can't be parking where they're parking legally. And provide notice, and then move forward with the towing with a licensed, bonded, insured towing company and proper signage placed at the association. So people, if their car gets towed, they know where to go get it. Okay, question number 19. We have an architecture form and review process for homeowners that includes windows, outside doors. It's very clear. However, some owners have received approval for installations. The owner installing company is not abiding by the requirements outlined in the architectural approval document. Challenge is now not abiding by the architecture guidelines and changing the uniformity of the community. I find out that we do not have our management company ensure that the owners have built or replaced in compliance with what they submitted. So what are our options? Okay, a couple of thoughts. There should always be, for large things, right, there should always be the application, the approval, right, and then after it's done, there should be a check to make sure that what they did is they built what was approved. So you need to communicate with your management company. Hey, that's one of our things that you are responsible for. So there's an application, we approved it at the end of the project. The homeowner needs to contact the management company and have the management company go out there and take a look at it, make sure that they built what they said they would build. And that should all be incorporated in your approval. Say that. Have it on the form. We're approving this. However, you have to invite us over after the project is completed to ensure that you built, to the standard that was approved. If you have owners that have put something in that is not what was approved, you probably need to get your attorney involved. There needs to be a violation letter. Maybe we're going to go to the ADRE and file a complaint and have an administrative law judge look at this. Maybe we're going to file a lawsuit. Maybe it's so minor it doesn't matter. But you want to talk to your legal counsel and come up with a strategy as to what your rights are, what your probability of success is, and how much it's going to cost to pursue this violation. Question number 20 from a board. Is it easier and less expensive to revise the bylaws and the rules and the CC&Rs? Great question. So yes, probably in theory, yes, it's easier to amend the rules, right? Because the board can pass them. Most of the time, the board can vote. A majority of the board can vote to make rules. The bylaws typically have a easier amendment provision. Like usually, it's not as stringent or it's higher percentage. But that being said, you can't go around the CC&Rs and amend the bylaws and the rules to amend a section that needs to be in the CC&Rs. So if you have something in the CC&Rs that says a particular thing like insurance requirements or how many board members there should be, the CC&Rs, we go back to the hierarchy of documents, the CC&Rs control. So you can't amend the bylaws and the rules to contradict the CC&Rs because the hierarchy, stops that. You also can't amend the bylaws or the rules for something that needs to be in the CC&Rs. CC&Rs have the use restrictions, right? The bylaws of how to run the board, right? How to run the association issues. When is the annual meeting? It's not, it shouldn't be a rental restriction. It should never be in the rules or the bylaws. That is a use restriction that needs to be in the CC&Rs. So if you're thinking about doing an amendment, you really need to bring in your attorney and get some practical advice about what you can and can't put in each of the documents. Okay, last question for today on St. Patrick's Day. Our board has changed rules regarding visitor parking usage on a trial basis. Is the board allowed to change the CC&Rs like that? Okay, so a little confused on this question. So you have rules regarding visitor parking, and you implemented those on a trial basis, but apparently your CC&Rs have something on this as well. So again, it's kind of the same question as the prior one. You can't pass rules for something that should be in the CC&Rs. So if I were looking at your issue for your association, I would go to the CC&Rs and look at what it says about rules. Like, how broad is the rulemaking authority? Is this something that's a use restriction that needs to be in the CC&Rs? It probably is. So you probably can't go around the CC&R amendment provisions and just pass a rule if it's something that really should be in the CC&Rs. But again, we've got to look at how broad the rulemaking authority is. Maybe it says the board can pass rules regarding parking in the community, or maybe it says the board can pass rules regarding anything pertaining to the common areas. And there's nothing about visitor parking in the CC&Rs, and maybe you might be able to do it. But dial in your attorney and talk about the issues so that you do it the right way. Okay, some concluding remarks. We had over 148 viewers at peak on Zoom and several more on Facebook Live. So over 150 people joining us here today for this class. Amazing turnout. Thank you so much for being here today. Let's talk about our upcoming opportunities to learn for board members, managers, and owners in April. So we have our first Fridays in April on Friday, April 3rd, and that's where you can ask any question at no charge, and we hop on Zoom at 9 a.m. and answer all the questions. You can find out how to do that by going to our website at mulcahylawfirm.com, sign up and ask your question, and we answer them live starting at 9 o'clock on April 3rd. We also have our fourth class for the Virtual HOA Academy that I'm teaching in conjunction with numerous cities and towns in the Valley. And that is going to be Tuesday, April 21st, 2026 at 11 a.m. on Zoom and Facebook Live. And we're going to be talking about kind of a scary topic. We're going to talk about ethics, accountability, fraud prevention for HOAs and condo boards. So we're going to talk about, the financial side, what to be careful for, to make sure that we're not having fraud in your community. We're going to talk about ethics of serving on a board. What is a conflict of interest? What do you do if there is one? How do you avoid them? These are all really great topics for us for a class in April. So I hope that you will be able to join us for that class. Just concluding remarks for today. Happy St. Patrick's Day. I hope you have a wonderful day today. And we look forward to seeing you at our 2 free virtual educational opportunities in April 2026. Take care, everybody. Have a great day.